The Sex Offender Registry. How did we get here? In 1938, the Los Angeles Police Department established its Bureau of Sex Offenses. The Bureau kept records, fingerprints, and photographs of people convicted of sex crimes and performed psychiatric evaluations of the people arrested on sex charges. In 1945, California passed the nation's first sex offender registration law in order to give police departments a way to keep track of known offenders by creating a list of suspects for use when new crimes occurred. By 1990, Washington State became the first state to enact a sexual predator law establishing a registry, community notification, indefinite sentencing, a tiered system of perceived risk, and a civil commitment law. In 1994, the Jacob Wetterling Crimes Against Children and Sexually Violent Offender Registration Act required all states to establish their own registries. Indiana passed Zachary's Law and was the first state to place their registry online. In 1995, Florida passed the first ever residence restriction law, restricting where sex offenders can live. In 1996, Megan's Law, an amendment to the Jacob Wetterling Act, required community notification for certain sex offenders and placed many records on the then relatively new World Wide Web. In 1998, Delaware became the first state to pass a sex offender ID card law, marking the state-issued driver's licenses and ID cards with the letter Y. Many states have followed suit since then. In 2003, the Supreme Court of the United States upheld Megan's Law in Connecticut Department of Public Safety v. Doe and in Smith v. Doe. By 2005, Florida had passed the Jessica Lunsford Act, which included strict mandatory minimum laws for sexual offenses. In 2006, the Adam Walsh Act established new national standards for the registries, assessed penalties on states that didn't follow them, built a national internet database of offenders, established an office to track them, and expanded the registries. Today, almost 1 million people can be found on the Sex Offender Registry. 26% of them are children, some of them as young as 8 years old. Some of the things that can put you on the registry: playing doctor, streaking, urinating in public, teenage consensual sex, sexual activities that occur when intoxicated. Some states even allow you to be put on the registry for testing positive for HIV. Other states have prostitution laws, which can result in a listing on the registry, sexting laws, and even laws prohibiting consensual kink. The Sex Offender Registry is a classic example of good intentions gone wrong. NARSOL, the National Association for Rational Sexual Offense Laws, envisions a society free from public shaming, dehumanizing registries, discrimination, and unconstitutional laws. NARSOL opposes dehumanizing registries and works to eliminate discrimination, banishment, vigilantism against persons accused or convicted of sexual offenses through the use of impact litigation, public education, legislative advocacy, and media outreach in order to reintegrate and reconcile affected individuals and restore their constitutional rights. If you'd like to learn more about what the National Association for Rational Sexual Offense Laws does, visit narsol.org to learn more.